Evicting a tenant can seem like a complicated process, but in this video, we'll quickly explain eviction laws in Delaware and how to recover your property in 5 simple steps. First, what is an eviction? Eviction is the process of legally removing a tenant. It's illegal for a landlord to change locks or physically remove a tenant themselves. So, if the renter refuses to leave after violating their lease, you must seek an eviction from the court. The process for simply terminating a lease differs from that of an eviction. Lease terminations require proper notice from the landlord or tenant, and state requirements can be found on our website. Legal reasons for eviction in Delaware. A landlord only has grounds to evict a tenant for reasons allowable in the state. The first step in the eviction process is to give the lessee one of the following notices. Non-payment of rent. If the tenant is late on rent, you can serve them a 5-day notice to pay or quit. This gives them 5 days to pay the rent in full along with any penalties, or vacate the property. Non-compliance. If the tenant violates their lease, a non-compliance notice gives the tenant 7 days to either comply with the lease or vacate the property. Irreparable harm. If the tenant causes or threatens to cause irreparable harm to a person or property, you may immediately terminate the tenant. Rent grace period. In Delaware, there is no rent grace period. Rent is due on the due date. An eviction notice can be served if the rent is only 1 day late. However, a landlord cannot change late fees until 5 days after the due date. 5 steps to legally evicting a tenant in Delaware. Serve the notice to quit. Choose the form you need and download or fill it out on eForms.com. Post it on the tenant's door and also send it via certified mail with a return receipt requested via USPS. If the breach is curable, you must wait for the specified number of days to give the tenant a chance to fix the problem. File eviction papers with the court. If the tenant doesn't fix the breach and remains on the property, the following documents should be filed in the court in the county in which the property is located. Complaint. You can fill a form out online with an interactive form filler. Go to the link through our website at the link below. Setting a hearing. After filing the complaint, the tenant will be served by the court and a trial date will be set. Wait for a decision. Bring all supporting documents to the hearing. If the court awards a judgment in your favor, the tenant will be ordered to vacate. Writ of possession. If the judgment is awarded and the tenant still does not vacate, you can request a writ of possession from the court. If this is awarded, the landlord can contact the local sheriff's office to remove the tenant and their possessions. Damages. Often the tenant's security deposit does not cover total losses. If damages are not awarded at the hearing, you may be able to recover past due rent and court fees through small claims court. Now you can get eviction proceedings started. Get eviction forms, court documents, and all other information you'll need at the link below for free.